I always like to set the stage for this program to give everyone a sense of why today's topic is even important. An executive of the Coca-Cola Company was once asked, "What do you consider your company's most valuable asset to be?" He said, "Without question, it is our registered trademark. We could lose everything we have as a business, be able to build again as long as we still had that registered mark." Most small businesses, new entrepreneurs fail to view a trademark in that way. So I hope through today's presentation, you'll start thinking, gee, this really is important to me. Next slide. So today we're going to have 5 different modules, and as Tracy indicated, after each module, we'll take time for questions. So let's begin with really the most basic thing, and that's covered in module 1. Next slide. And that is just the definition of what a trademark and service mark is and the various types of marks. Next slide. So what is a trademark or a service mark? Well, it's any word, any symbol, any design or combination of those. And then there are 2 important buzzwords. The first identifies the source of the goods or services. And the second part is that it distinguishes those from the goods or services of another party. Next slide. So basically, a trademark is specifically for goods or products. A service mark, as the name implies, it covers services. But otherwise, they're basically the same thing. And so I'll probably say trademark. If what you're doing is providing a service, then remember in the context, that's going to be a service mark for you. So you've probably have seen the symbols. Well, you all could start using the TM or the SM today, even if you've never applied to seek federal registration. That is your mark, and you're entitled to use the symbols of TM or SM. The only time you are to use the R in a circle is when you have successfully registered the trademark. Now, use of the symbols, it's not required, but it's helpful to use them because it puts the public on notice that you are claiming ownership rights. Next slide. Now, there are various types of marks. And when you're thinking of applying, you really have to figure out, well, what would really be appropriate for my business? You might want to think of first registering just the basic word mark. It also says and slogan, because a slogan is basically simply more words in the mark. Shown there is Coca-Cola. That is presented in what we call the standard character format. What that is saying is you're really trying to protect the words themselves without any particular care of the style of the mark in terms of font, color. That gives you the most protection because you're not locked in to any particular font or style. Now, if you are worried about the manner of presentation of the wording, then that would be a special form mark shown there in the famous Coca-Cola script. If you apply in that manner, that means you are particularly worried about how that particular wording is presented. Now, a composite mark is where it consists of not only wording, but a design element. Now, here it's shown in color, but one of the things that you may think about is applying in black and white. That gives you more flexibility. It says that you could start using it in, let's say, the blue and red shown here, but if in fact later on you decide, well, I really don't want to use it in blue and red, filing in black and white allows you to switch the colors. Again, it gives you more flexibility. And the fourth is a design mark. If it's simply a design with no wording, then that is how it's characterized as a design mark. Now, these are the most basic types of marks, but there are other things that can in fact function as a trademark or service mark. Next slide. And these are the other types of marks. Configuration or shape, that would be something like the shape of a Weber grill or the shape of a Volkswagen Bug. You see that car coming down the street, you know it is based on the shape from Volkswagen. Sound would be sound of a lion roaring at the beginning of a movie, registered to MGM. Color, a brown truck, even without seeing the wording UPS, you know that it's coming from UPS because they've successfully marketed what can brown do for you. Color brown registered as a mark. A scent or smell mark. The most recent one that we've registered is for Play-Doh. If you remember as a child playing with Play-Doh, it has a very distinctive smell, and that smell is now registered as a mark. We have some motion marks registered. We have some holograms. Always remember that anything that functions as a source identifier may in fact be registered as a trademark. Next slide. Now, always remember that a domain name is not the same as a trademark registration. A domain name is a website address, a URL. It's important in today's business world to have a website, but again, that will not give trademark protection. Similarly, a business name. To do business in the state of Virginia, you must register your business name. That is simply saying that you are doing business under that name. It does not, again, give trademark protection. Now, it may be that the business name ends up being a trademark, but just because you have the business name registered at the state level, again, does not automatically afford trademark protection. Next slide. So that's kind of the introduction to the topic, and we'll take some questions on this first module now.
Craig, we don't have any current questions typed in.
Okay, then we'll go on to the next module. And remember, at the end, we're going to have time for any questions that were not covered in the specific modules, so don't worry that you've missed your chance. But next slide.
Real quick, folks, I see a couple people have raised hands. Here we go. Will you be covering how to go about registering?
Yes, that is in a later module.
Okay. And so are you saying that from a design perspective of a logo identity for a company, is it best to only get the TM on the black and white version to allow for maximum flexibility?
Correct. That gives you the most flexibility. And because we allow that as a filing option, you should definitely consider that. Again, we understand you're not going to be using it in black and white, but in terms of applying, when you apply in black and white, that gives you the opportunity to change the colors and still have the underlying registration support that.
Okay. Did I hear you correctly that you can use the TM symbol prior to actually registering?
Correct. As long as you are adopting that as your mark, you are entitled to use the TM or the SM symbol. You can do that starting today. You simply are not to use the R in a circle, though, until you've actually received the federal registration.
So I can register the smell of my beverage. How can I describe that to the USPTO? How about taste?
Be careful there. If it's an integral function of the product, then that will not be registrable. We register something that would not normally have a smell. The first mark to be registered was the scent of yarn. Yarn normally does not have a smell, and the fact that someone said, well, I'm making my yarn smell like a particular flower, we said, well, people are going to recognize that as a trademark. But a beverage or perfume, for example, that simply have smells normally, then that would not be protectable. It's just that is part of the product itself, and it normally has a smell, so that would not be a source identifier.
Can you register your birth name?
You are able to register a name, but if it is simply a surname, then that is not registrable under our statute unless you are able to establish that people, in fact, are recognizing it as a source identifier. So McDonald's, for example, well, McDonald's clearly a surname, but they were able to show that it had become distinctive. Once you sell a certain number of hamburgers under that mark, it becomes distinctive. A full name, not the same problem. You simply have to give consent to register that, so that's not the same problem as being primarily merely a surname.
Back to the smell taste question. What if the smell taste is not normally found in a particular beverage? Could you register that?
Then that possibly will be registrable. I can't give a black and white answer on some of these things, so I can only say, well, it may be possible, and we'll have to leave it at that.
Okay. If after registering, do you drop the TMSN and go strictly with the R?
That is correct. Once registered, you should use the R in a circle.
Does using the TM or SM before you have registered protect you?
Could you repeat that, please?
Does using the TN or SM symbol before you have registered protect you?
Well, neither the TM, SM, or the R in a circle protect you. In the context, it simply puts the public on notice that you are claiming rights in that particular trademark. Always remember that the registration is not in and of itself protection. It simply, again, puts the public on notice, but in terms of protection, and we'll cover this, excuse me, in the later module, you have to enforce your own rights. Just because you have the registration, it does not automatically mean that someone else will not try to use a similar mark.
How do you protect original artwork?
That is done through copyright. The U.S. Copyright Office, part of the Library of Congress. That is not a function of the USPTO.
Why is a URL not? Go ahead. Do you want to go ahead and take this one last one, and then we'll save the rest of them to the end of the presentation?
Yes, I think we should.
Okay, I switched the slides there. Why is a URL not covered by the Trademark Office?
Because it simply is not normally viewed as being a source identifier. I say normally not. There certainly are times, for example, Amazon.com. Amazon uses that in the manner of an actual trademark. It's not simply used as a website address. It's also used in the manner of a mark. So it really does turn on the manner of use. And if it's solely used as a website address, then it's not functioning as a trademark. So it really turns on the manner of use to make that determination.
Okay, great. We'll go on and then we'll save some of these for the end. Here we go. Oops.
So the next topic is, what are the benefits of federal registration? Next slide. Well, before understanding the benefits of federal registration, you have to understand there's such things as common law trademarks. What is common law trademark? Well, this is a mark that is simply used in commerce, but it is not registered. Now, under the common law, the rights associated therewith are specifically tied to the geographic area. Where is the mark being used? So if it's only being used, let's say, in a 20-mile radius of Lexington, Virginia, then the rights are limited to that particular geographic area. Now, you're still able to use the TM and the SM symbol. And then the most important thing is that under US law, whoever actually uses the mark first will have superior rights. And this is where it gets very confusing. It's possible that you successfully register your mark and someone asserts that they have superior rights. How is that possible? Well, again, under the common law, if that party has used the mark before you did, even though you successfully registered the mark, they will have superior rights. So it's always important to be aware of the possibility of someone asserting common law rights. Next slide. But there are rights associated with the federal registration that you simply cannot get under the common law. And the first is that there's a legal presumption that you own the mark and have rights in all 50 states and our US territories, but not other countries. This is only a federal registration, and if you want rights in another country, you must deal with the trademark office of that specific country. Again, registration allows use of the R in a circle symbol, and through registration, you're automatically going to be listed in the USPTO database. Next slide. And here are some other rights. That second bullet is important if you're aware of infringing goods coming into the country, then you're able to take your registration and record it with US Customs and Border Protection. US Customs and Border Protection, they are not able to keep out infringing goods if you have not taken the step of actually recording with them. So that's a very important piece. And then that last bullet, if you're interested in protection elsewhere, the important buzzword is the Madrid Protocol. Through our website, you can use that as a search word. Again, to have protection in another country, you'll have to deal with the trademark office of that specific country. Next slide. Okay, so we're already at questions. Again, it can be the module we just covered, or if something was not answered from the first module, we can circle back here.
Okay. Well, let me start with one we just asked on this section. If a business is online based, what would the radius for the common law right for that business if it ships all over the country?
Right. Well, that's where things have gotten a little murky, if you will. It used to be fairly clear that the radius was much smaller, and the internet has actually changed that. And some legal scholars think that common law rights, once you have a website, that the rights really do extend through the whole country. So if you do have an online business and you are getting orders, you're based, for example, in Virginia, but you're getting orders from California, then it's possible to assert that your common law rights do extend throughout the whole country.
Okay. All right. Is there, I think you'll probably answer that in a little bit. Just to clarify, does trademarking our logo or design mark only protect our mark from others using similar marks that are in the same industry? So if a similar mark is found being used elsewhere in a different industry, is it okay for both to exist?
I'm definitely going to cover that in the next module, so we'll put that in our back pocket for now.
Okay. I'm working with a co-packer to formulate and develop my product. Can I trademark my recipes as original to my company?
Recipes are not protectable. They are usually considered to be trade secrets, so that's why we don't know the recipe. For example, for Kentucky Fried Chicken, we don't know the specific formulation for Coca-Cola. Recipes simply are not protectable as intellectual property.
How does one research if common law already exists or has existed for a long time on a mark?
I'll cover that one in the next module.
Okay. So trademarks are just for your logo primarily?
Or words. You don't have to have a design element. It can simply be words by itself, but often people do refer to the trademark as a logo because that's what they're used to seeing. If you can visualize, for example, Nike, they have the word Nike protected. They have the swoosh protected, and then they have their slogan, just do it, protected.
My business name is Lamar Active. Is that something that could be registered? Lamar is my surname.
I couldn't hear the last part.
Lamar is the person's surname. So it's their last name and then activewear. Is that something that could be trademarked?
Well, again, remember that under the trademark statute, a mark that is considered to be primarily merely a surname is only registrable if you can establish that it has acquired distinctiveness. And the addition of a generic term to a surname, it will still be considered as being primarily merely a surname. So you would have to be able to show that normally the standard is that you have used the mark for at least 5 years to establish that the public will view it as a trademark, again, that has acquired distinctiveness.
How do I physically source the R logo and put it next to my name? Should it go on top or bottom or always after?
There's no particular requirement as to the placement. Normally it is to the right of the mark, the upper side, but there, again, no specific requirement where that appears. Nor, again, is there a specific requirement that it is ever shown, but it is advantageous to you, again, to put the public on notice that you're claiming rights.
What requirements must be met to satisfy proof as use of our mark? For example, if we have a physical product in packaging and development for several years, and in the meantime show our mark displayed on a website, but not necessarily advertising our product in the online shop yet, is that enough?
So let's put that one in our back pocket as well, and I will cover that when we're talking about the actual filing process.
Okay.
And
I think we're going to hold the other ones. There are some specifics of, is this trademark or copyright? Let's get to those at the end and go on with the presentation.
Okay. So this next module is selecting a mark. Next slide. So there are certain challenges to be aware of when you are trying to come up with your mark. And the first is, bottom line, not every mark is in fact registrable, and filing fees are not refundable. So even if you apply and for whatever reason are not granted the registration, remember that the filing fee is simply not refundable.
There you go.
I think we've gotten a little off track there. Okay, here we are. So remember that you're not buying a trademark. You're simply applying to seek federal registration, and it's not guaranteed. Also remember that not every mark is going to be enforceable. And this is the point that we covered before, that even if the mark is registered, there's always a possibility that another party is going to assert they have superior common law rights. Next slide. Now, one of the first things to worry about when you're trying to come up with your mark is you have to make sure that you're avoiding what in legal terms is known as a likelihood of confusion. That's confusion as to the source of the goods or services. And we look at two very specific things, and this ties back to one of the earlier questions. The first is, are the marks confusingly similar? They don't have to be the same, they simply have to be similar in some way. For example, are they similar in sound, appearance, overall commercial impression? And then the second part of the test, are the goods or services somehow related? Again, they don't have to be the same, they simply have to be related. Identical marks can coexist in the marketplace if the goods or services simply are not related. So you could have Dove, for example, Dove for a bar of soap and Dove for an ice cream bar. Trademarks Dove identical, but there's no likelihood of confusion because the goods simply are not related. Next. Now, in order to avoid this possibility, we recommend that you do a search. Now, you're able to do a search on your own using the USPTO database. So from our website, you're looking for the Trademark Electronic Search System, or TESS for short. The easiest way to find TESS is on the front page of our website. That's uspto.gov. The upper right, there's a Find It Fast feature. If you expand trademarks, the first listing there is going to be for TESS. Now, TESS is only a database of all federal registrations and applications. And one of the questions was, well, how do I search for common law use? Well, you would search the same way that you search for anything else using the internet. So you're doing a search to try to find a story of, let's say, a new business that has opened up. And if you see that the business is the same name as what you want to use, then you have to do a little research, because you have to find out, well, when did they first use the mark? Because again, whoever used the mark first is going to have superior common law rights. But the test under the common law, it's always the same. Are the marks similar, and are the goods or services related? So those are your two options for searching on your own, using the TESS system or doing an internet search. Next slide. The other option is to hire a private attorney or a search firm, and they're going to do a full clearance search, and they're going to do searches of everything listed there. We always recommend, however, that you at least try to do your own search. Why is that? Well, even if you don't do a great search, if you do a search and you uncover at least one instance of someone who has registered the mark, that's going to be enough to tell you it's time to think about selecting a different mark. Your search perhaps did not uncover all possibilities, but you don't have to know all possibilities. If you even know of one example of someone already having secured rights in that mark, then again, it's time to start thinking of selecting a different trademark. Again, not a great search, but at least it has uncovered something. But you may want to think again of hiring a trademark attorney or a search firm, because they can do the full clearance search for you. Next. The other thing to worry about, besides avoiding likelihood of confusion, is to make sure you're selecting a strong trademark. Marks can vary in strength from strong to weak, and since you have the opportunity to select a strong one, you should do so. The strongest type of mark is a mark that is either fanciful or arbitrary. A fanciful mark is something like Xerox or Kodak, words that never existed in our language until someone said, I want to adopt that to be a source identifier. Well, a source identifier, again, a trademark, as strong as possible because adopted for that purpose. An arbitrary mark is something like Apple for computers, a real word in the dictionary, but the relationship between the word itself and the product is totally arbitrary, so a very strong mark. A suggestive mark, slightly less strong, that would be something like Coppertone for suntan lotion. That suggests that if you use the lotion, your skin will turn a beautiful copper tone. You have to think about that a little bit, so it's still okay. Contrasted with the next level down, descriptive. Descriptive would be something like creamy for yogurt. It describes a characteristic of the product. Descriptive marks are difficult to register. They are difficult to protect. Not impossible, but more difficult. So you should always try to be above that line. At least it's suggestive, or even better, fanciful or arbitrary. Now there is one final category, and that is generic. That is the actual name for a product or service. So if you were, let's say, coming up with a new dairy-based beverage, you really couldn't say, and my trademark is milk. That is simply the generic term for that product. Now you might be thinking, well, I understand this. This would be something like Kleenex. Well, that's not correct. Kleenex is still a registered mark. Proper use is a Kleenex brand facial tissue. The true generic there is facial tissue, but Kleenex brand, still a registered trademark. Next slide. Okay, so here we have time for some more questions.
How close together are the categories? For example, a beverage name versus a wine name.
They are considered to be related. Related is, think in terms of your experience as just a general consumer, where you're aware how products are sold. So if they're sold in the same area of a store, for example, then they would be considered to be related. So beer and wine, for example, they are clearly different types of beverages, but for the purposes of analysis of the likelihood of confusion, they would definitely be considered to be related.
Can you give an example of a strong and weak service mark?
Well, off the top of my head, I would have to go back to the example that I already gave of Xerox. Xerox, they certainly are registered for a product, but I believe that they also are registered for the service of actually servicing their machines. And because that's a totally made up word, it's as strong as possible.
What category would you consider Starbucks?
Could you repeat that?
What category would you consider Starbucks?
The last word, Tracy, I'm missing. I'm
Starbucks,
sorry.
As in the coffee company, Starbucks.
Oh, Starbucks. I'm sorry. So they probably are in the category where all retail services are placed. So it's a retail store in the nature of providing beverages. When we talk of categories, and this will come up in the next module, but we'll cover this now. All goods and services are placed in one of 45 different international classes. Computers, for example, are in class 9. Shirts are in class 25. Now, you heard me use the word international. That's simply because all countries in the world use this same classification system. Again, you're not getting international protection. You're only getting protection in the United States. But again, the classification system, it's called international class because it's used throughout the world. And that's going to come up in the next module because it factors into the cost of your trademark application.
Is it advisable to hire an attorney to do this, or can we do this ourselves?
The USPTO does recommend that you hire an attorney simply because you are beginning a legal proceeding. It is not required, but you're more likely to be successful if you use an attorney. If you are not able to use an attorney, then we'll cover in the last module some other resources for you. That will be kind of the last thing we talk about today.
Okay.
I want to circle back on one other thing as far as those classes. A lot of people will mistakenly think, oh, well, my class is whatever, and their goods are in a different class. Being in a different class does not in and of itself establish that the goods are not related. For example, handbags are in class 18 and clothing items are in class 25. They are different classes. However, we consider those goods to be related goods. So classification in and of itself is not determinative as to whether the goods are or are not related. Okay, let's go ahead, Tracy, to the next module. So we're now going to talk about filing and the registration process itself. Next. So you've given the consideration to coming up with a mark that we hope that you have done your legwork, your homework, and determined that they're, to the best of your ability, there's no likelihood of confusion, and it is a strong mark. Well, we hope at that point that you will go ahead and file to seek federal registration. And you're going to do this through our website, and you will be using the Trademark Electronic Application System, or TEAS for short. Electronic filing is mandatory except in very rare situations. So if you're interested in filing, you're going to do so through TEAS. Now you're going to have a basis for filing, and it can be one of two things. Either use in commerce, that you're already using the mark in interstate commerce or between the US and another country, or you can file based on what is known as intent to use. And that's where you haven't used the mark yet, but you have a bona fide or good faith intent to use the mark in the future. Now, intent to use is simply a filing basis. It's not an actual basis for registration. Before your mark will register, you will have to do another submission showing that you're actually using the mark in commerce. Let's circle back to an earlier question. How are you going to establish that you're using the mark? You have to submit what is known as a specimen, and that is a sample of how you're using the mark in commerce. So you're going to upload, as part of the electronic form, a digital photograph of, for example, the product itself, showing that the mark is used on the front of the product, or perhaps it's used on a label or a hang tag. Then you submit the photograph of that, but you're going to do so in the context of use. For example, we want to see that it's a hang tag attached to a shirt, for example. I think one of the earlier questions was, what about if my use is on the front page of my website? There are certain requirements for use in that manner to establish that it is, in fact, a viable specimen. You have to be able to show that there is a way to order the product directly from the front page of the website. So if you're simply using it on the front page, but you're not satisfying other requirements, then it may not be acceptable as a good specimen. Next slide. Now, everyone always wants to know, well, how much is the application going to cost? Well, there's a little formula that you have to be aware of, and fortunately, we've covered part of this. The dollar amount is going to be either $225 or $275, depending whether you use the TEAS Plus version of the form or the TEAS Standard. What is the difference? Well, the TEAS Plus version, it requires that you use an identification of goods or services that appears in our acceptable manual of terms for goods or services. Because we have already determined that that listing is acceptable, we do less work on our end, so we pass the savings on to you. That's why the TEAS Plus version has the lower filing fee of $225. If you have a very new product and that listing does not appear yet in our manual, then you would be required to use TEAS Standard at $275. You would be entering a free text version of the terminology. You type it into the form. Then we have to determine through examination whether it is acceptable. And then the second part of the formula is what I mentioned earlier. It is always times the number of classes. So again, you only have one mark in the application, but if you're using that mark in connection with, hypothetically, computers in class 9 and shirts in class 25, it would be times 2. If you also have, let's say, beer that we mentioned earlier, well, beer is in class 32, so it would be times 3. Now, don't worry if you're thinking, well, gee, I have shirts, pants, shoes, hats, jackets. This is going to be very expensive because I'm already up to 5. No, all those goods are in the same class, so it is only times 1. It's only when you have different international classes do you have to worry about times 2, times 3, etc. Now, always remember too, if you file based on intent to use, that another filing will be required to show that you're actually using the mark, and there is an additional fee associated with that filing. Next slide. Now, we want to be sure you're aware that all information within your application is going to become public information. And this has become a big problem for us because companies are now sending notifications that look very official using names very similar to the USPTO. And they will indicate that you have to pay an additional fee to keep your application in the examination process. Very misleading. The USPTO does not send out any invoices. So if you receive something in the mail that is requiring a fee payment, it is not from the USPTO. We have a certain page on our website where we highlight all of the solicitations that we are aware of. So always go to that page if you've received something to check whether in fact it is legitimate. The USPTO controls the domain at uspto.gov, and we are going to be corresponding with you through email. So if you receive anything that is not from that domain, then it is not from us. And if you receive anything that is not from Alexandria, Virginia, then it is not from us. So be very careful about this. And if you have any questions, always contact us. Always ask first. Do not pay first. Always ask first. Again, the USPTO has no relationship with these companies, and unfortunately, we can't help get your money back. So be very careful about this. Next slide. Now, it is the mission of the USPTO to register any mark that is in fact eligible for registration, and we're going to try to help you. We're going to try to work with you, because ultimately that is our mission. Always remember, though, that the USPTO has no enforcement powers, and I mentioned this earlier, that it is going to be your responsibility if you're aware of someone who is infringing on your trademark, then you're going to have to use your registration to try to stop them. And that is your right, but also your responsibility to enforce your rights. The USPTO has no role in the enforcement process. Next slide. I always say you should view your registration as a sword and not a shield. What do I mean by that? Well, just because you have a registration does not mean that no one else will try to use a similar mark, okay? So you have to use the registration as a sword, to use it as a basis to support a cease and desist letter. Don't sit back and think, well, just because I have this registered, that it is some kind of shield. Someone out there may try to, again, use the infringing mark, and you have to step up to the plate and try to stop it. Next. Unlike a copyright or a patent that is only good for a certain number of years, a trademark can last forever. But there are certain requirements that you have to make sure that you're keeping up with, what we call maintenance filings. Between the 5th and 6th year after registration, you have to do another filing showing that you're still using the mark, and that's called a Section 8 declaration. You could also combine that with what is known as the Section 15 declaration, to establish that the mark is incontestable. What does that mean? It means that it can't be challenged by anyone trying to cancel the mark. Then between the 9th and 10th year, you have to do another filing showing that you're still using the mark, and to request renewal. And that's called a combined Section 8 and 9. The good news is the USPTO will try to help you remember that it's time to do these filings by sending you an email reminder notice. So it's always important to keep your email address current in our database. If for any reason you change your email address, make sure that you do a filing through the online change of correspondence address form to update that address to make sure you're getting the email reminder notice. Next. Okay, so questions?
Sure. How valid are the companies that advertise themselves as being able to patent register your products/ideas?
The USPTO position is that you should stay away from what we call filing factories. All they will do for you is file whatever you have asked them to file. That's really the sole role. They're not going to help you determine, for example, whether you shouldn't file because there's a likelihood of confusion or it's a very weak trademark. They get their money from submitting the application, and they will basically do whatever you ask them to do. So you're not really well served by using those kind of companies.
How do you satisfy the good specimen requirement when filing if your product is a service and not a regular product?
It's the same requirement. You have to submit a specimen. If you have, let's say, a brick and mortar store, then you take the photograph of the front of the store. If it is a website, again, it's possible for that to serve the function of a mark. You would take a screenshot. You can't simply provide the website address. You have to take a screenshot of the front page of the website. Again, always think, how do you encounter service marks in the marketplace? Well, you need to do the same thing. Use the mark in that manner and then submit the specimen showing that particular manner of use.
What if you had an approved trademark but did not complete the Section 8 declaration? Do you start from the beginning?
Yes, if for some reason you did not satisfy the maintenance requirement, then unfortunately you have to start over from the very beginning with a new filing.
Can my logo be hand drawn? How much detail is needed in the filing?
It can be hand drawn. What the examining attorney is going to look at is a comparison of the mark itself as presented in the application and the mark as used on the specimen. We want those to be as close as possible. So a good hand drawing is acceptable, but you want it to look as professional as possible.
Craig, do you want to go ahead with the next session? We do have more questions, but we can hold those from other sessions.
Okay, so we'll get through the next section, and then we'll wrap up with questions. And this is, how do you find help? Next slide. So your main resource provided by the USPTO is going to be our website, uspto.gov. And one of the things that we offer there is a PDF booklet, basic facts about trademarks. If you don't want to read a booklet, all the information is also available in our video series listed there. Next slide. But someone asked this earlier, must I have an attorney? Well, again, that may be your best resource, to use an experienced trademark attorney. Remember that the USPTO, we are not able to provide legal advice, and we do not enforce your rights, nor can we recommend specific private attorneys. Next slide. But a resource that we do provide is the Trademark Assistance Center. So there is the phone number for the Assistance Center, or you can email the Assistance Center, or if you simply want background information as to what kind of information the Trademark Assistance Center could provide, there's a webpage devoted to that. The one thing though, please remember, we aren't able to provide
All right, folks, it looks like Craig has frozen up. So let us give it a few minutes. Hopefully it will either unfreeze or he'll jump out and come back on the session. At least we got through most of it that way. All right, well, since we are almost at the end of the hour, I'm gonna take this time that Craig's not with us to close up the session. And hopefully by the time I'm finished kind of walking through the thanks, he'll come back on so that we can answer the last few questions. So here he comes, and I'm just gonna tell you all,
Yep,
thank you.
I'm back, Tracy,
Oh, you're
sorry.
back already, there you go. All right, perfect. I didn't even have to go that long. Here you go.
Okay, so next slide.
So now we're at questions. All right.
Yeah.
What if my trademark is for software or computer class, but someone else have the same trademark name for a different class clothing? Can I use the trademark name and print clothing?
Right. So if it is software versus clothing, that's not considered to be related. So again, you can use identical trademarks and there's no likelihood of confusion because the goods simply are not related.
Are there classes which it does not make sense to apply for registration?
No, there's nothing specific as to a class where we would ever say, oh, well, it simply doesn't make sense to try to register that.
Why was beer 3 classes?
Could you repeat that?
It says, why was beer 3 classes?
No, there must have been a misunderstanding there. What I had said was if you had computers in class 9, clothing in class 25, and beer in class 32, that's where there were 3 classes. Beer in and of itself is only in class 32.
Okay. All right, well, so I'm going to go back up to some of the questions that were copyright versus trademark. Are formulations protectable? For example, a topical pain cream.
The last part of that again, Tracy?
For example, a topical pain cream. So a formula for a topical pain cream, is that protectable?
That may be protectable as a patent, but that would not be a trademark issue.
Okay. Is literature or children's book best copyrighted or trademarked?
That is copyright. So a copyright protects an original artistic or literary creation. So definitely a copyright issue.
If I have informational products, do I trademark or copyright?
So the information that is presented on an information sheet, for example, that would be a copyright issue.
Okay. This one was asked again. So the name of the person's podcast is their full name, Catherine, I'm going to butcher it, Abarash. What type of registration should I use for my podcast? TM? And then secondly, will the registration protect the content of my podcast? And do I need to TM my taglines?
So that would actually be a service mark rather than a trademark, because you're providing, let's say, an educational service in the field of whatever that might be through the podcast. So that is going to be a service mark. And then, yes, going back to the Nike example, just do it, registrable as a slogan or a tagline.
How long does it take to hear back on your application?
You will not hear anything back for approximately 3 months. because we get about 700,000 applications a year. So they all go into a waiting queue. So it's approximately 3 months until you will hear anything at all from us.
If my logo is weak, would it make it more difficult for someone else to claim that their similar logo is too similar?
Was the first part,
if my logo is weak?
So generally we don't consider logos to be weak unless the design element is also descriptive. Usually we think of logos as having a distinctive element, but where in general marks are weak, then there's not as much consideration given to a likelihood of confusion, because many people are using similar marks, and that's the problem with marks that are weak. They really don't serve the function of a mark in the same way that a strong mark will, because they're simply.
All right, well, it looks like Craig is frozen up. This time I am going to close this out because we're right at 1 o'clock. If Craig joins us back after I do that, we'll ask a few more questions. Thanks everyone for attending today's session. Greg gave us some great information during the session. You'll be receiving an email after the session, and the link will have an email or link to the recording as well as the evaluation. I have also put that link for the evaluation in the chat window in today's session. If you could take some time to fill that out, we would very much appreciate it. It helps us to improve our training sessions. For more information about upcoming training sessions throughout the state, that can be found on our website, virginiasbdc.org. But I would like to highlight 2 upcoming sessions that the Shenandoah Valley is sponsoring. On September 15th, they're doing a SWAM certification in EVA registration, and then on October 14th, they're doing a session on doing business with the Commonwealth. Also on the Virginia SBDC website, you can find the business recovery page, which we developed to help business owners continue business operations during this very challenging time. The detailed guidelines cover a broad range of critical considerations ranging from safety in the workplace guidance to financial assessment and marketing communications. Well, you can use them by themselves. They were developed to use with one of our counselors. So you can look on our website for your closest location. So Craig, I was just filling in time, closing out the webinar. Okay. I've got some more questions. I don't know what your time frame is this afternoon, but you just tell me when I have to stop asking them.
Well, with the pandemic, I have no place to go but here in my house, so I can stay as long as people are interested in having questions answers.
Okay. Is it best to trademark a logo and a tagline together or separately?
It really always turns on how they are used. If they are used together and you really can only afford to file one application, then you submit it together. But if they are used separately, then you might want to think about filing 2 applications. It's really a business decision in terms of how much money you want to spend.
Okay. If I'm an author and create a character to represent me, such as a cartoon figure that will appear on all my works and websites, do I trademark this or copyright this?
I just want to circle back before I forget, and then we'll get to that question. It's always very important to remember that in the examination process, we're going to look at that specimen to see how the mark is being used. Sometimes people will try to take a shortcut and they'll try to shoehorn elements into one application where in fact one element is used on, let's say, the front of the box, and the other element is used on the back of the box. They're not actually used together. And so when we look at the mark in the application, we see it in one way, and then we look at the specimen and we realize, well, wait a minute, there's not actually one mark here. So be very careful about that. Make sure that your use actually is identical to the mark as presented in the application. So the question that was just asked about characters, it's a difficult question because it really depends on the circumstances. There are some characters that have been successfully registered as marks. I don't feel comfortable really going into that because it's so case specific. I can't give kind of a general view on that. So bottom line, sometimes yes, sometimes no. And unfortunately, I can't give more information on that specifically.
Okay. Can I use a TM without the intention of applying for federal registration?
Absolutely. Remember, under the common law, you've adopted that as your mark, so you're able to use the TM symbol that's on one of the slides.
Can you confirm if there's a certain time frame that a mark must be used to be protected if it was never registered?
Repeat that one, please.
Can you confirm if there's a certain time frame that a mark must be used to be protected if it was never registered?
So as long as the mark has been continually used, the common law rights exist. If the use stops, then the common law rights also stop. And then if use is started again, then the common law rights start back up. But there's no specific time frames tied there too. It's just a question of, is there actual use?
We provide a service. We use a symbol as part of our name. Should we register the symbol, our name, or both?
Again, that would really turn on how they're being used, but whether to do one or both, that again goes back to what I'm calling the business decision in terms of how much you want to spend to possibly apply.
Are clothing and hair appliances like curling irons considered related goods?
Generally not.
Do we have to file each class? And then it says software after the that question. Do we have to file for each class?
Well, an application can consist of as many classes as you want within one application. You should always first determine, well, what is your primary business, and make sure that the class covers that. And again, if you're not able to afford, because it's going to be more expensive if it is a multi-class application, that's why you want to make sure you first figure, well, what is most important to me? And then if you have additional funds, you could always add other classes within the application, but always figure out, well, this is definitely the primary thing I'm interested in. Well, that should definitely be what is listed first in the application.
Can you include more than one thing on the application, or is it a separate application for each? For example, name, logo, slogan.
The application can consist of only one mark. Okay, so it may be, it's a composite mark, so it has both wording and a design, but if it's truly a different mark, then that would require a separate application. I also want to highlight that you cannot amend the mark, nor can you broaden the scope of the identification. So you really had to think about this at the beginning. So if, for example, you file just a word mark, you can't then come back to us and say, well, I've decided to add this design element, so I want to amend the mark. That would require a brand new filing. Similarly, if you're filing and you're not careful and you list only pants, and then next week you realize, oh, well, I also have shirts, you can't come back to us and say, I want to add shirts to my application. You may narrow the scope, but you may not broaden. You would have to do a new filing to protect the shirts.
How about a mark that is partially generic but changed to be partially fanciful? Peanut butter and Janelli.
So what that would get into is a legal term. It's called a disclaimer, where you would have to disclaim the generic portion to indicate that you're not claiming rights in that generic portion, because everyone should be entitled to use the generic wording. What makes the mark registrable is you have a distinctive element combined therewith, so that that's possible to register, but again, you're not getting rights in the generic portion.
Can you cover again the difference in protection geographically versus nationally? Is there a test as to if you only have protection in a delineated geographic area?
The test is simply how broadly consumers are being reached, and there's no way to definitively tell you how you would know that. It's part of kind of just being in business, knowing that your customer base is coming from a certain area, contrasted with knowing that you're reaching such a broad base, and that you have products being sent to California and sent to Maine and sent to Minnesota. You should be able to pretty much figure that out, again, just based on your own business experience. Again, there was that wrinkle we talked about, that if you have a website, that it may be possible in today's business world to say, well, my reach is as far as my website, and that makes my common law reach much greater.
So Craig, I know on one of your slides you talked about not being able to recommend attorneys or lawyers in all of this. We do have a couple of questions about, what is a typical fee that somebody might need to spend, and is there any source that you know of lower cost alternatives to the lawyers?
So unfortunately, I really can't talk about fees in terms of what a private attorney would charge. There certainly would be a range, and in part that depends on the geographic area where you're located. There may be differences in costs, but what I can speak to is what some other options are. Obviously, one of the options is the SBDC. That's why we're doing this program today. There are also law schools that have clinic programs on our website. You can look using that as a search, law school clinic, and they offer some free services, so that could be a resource for you as well. Again, remember that the USPTO website is also going to have a lot of free resources available. There wasn't a question about this in today's session, but in another session, someone asked, does it cost anything to use the USPTO search system? No, that is a free system. available to you to perform your search. The only actual USPTO fee is the filing fee for submitting the application.
Great. So we're down to the final two questions. Is it generally better when describing a good that I am offering more generically or more specifically when applying for registration? That is, should I make my description longer and more generic to cover more areas for possible protection, or should I be extremely specific, just like in the black and white logo question, but with words?
Okay, what you want to do is come up with an identification that uses common everyday language, so someone who is reading that identification will understand what your product is or what your service is. You do not want to go too narrow. For example, you are able to use the identification of shirts. Now, it may be that you are specifically doing long sleeve button down shirts, but that would be too narrow. You want to use the broadest terminology that is accurate. You want to make sure that it accurately describes your goods or services, but you do not want to make it so narrow. Why is that? Well, let's say today you're doing long sleeve button down shirts, but next week you decide to start making polo shirts. Well, if you identify it in such a narrow way as long sleeve button down shirts, then your polo shirts are not going to be covered. So you want to, again, go broad, but just make sure that it is accurate. And in terms of that, when you look in our manual of acceptable identifications of goods and services, remember I said that the T's plus application form requires that you use the listing from the manual. Well, again, don't try to cut a corner and say, well, this listing isn't exactly what I do, but I want to save money. I want to file under T's plus, so I'm going to select this even though it's not truly accurate. What's going to happen is the examining attorney is going to review that and is going to reject the application when he or she figures out, well, this application was filed with that listing, but that's not really what the applicant is doing. That is the basis for rejection. So be very careful about that.
Right. Final question. If your application gets denied, do you get to make corrections to the application, or do you have to submit a new application and fee?
So it depends on the basis for the refusal. For example, if the rejection was based on the examining attorney determining that there is a likelihood of confusion with a registered mark, he or she will send a letter that fully explains the basis for the refusal. But then you have an opportunity to come back and try to educate the examiner to explain, for example, why the goods or services really are not related, even though the examining attorney may have thought that they were. So you have the opportunity to make your case, and perhaps the examiner will come back and say, yes, I agree with that. I am going to not hold this refusal going forward. There are some grounds that you simply cannot overcome. Again, one of the examples that I just discussed was if in fact you're not truly using the mark on the goods that you have listed, then you can't change to a different set of goods. So bottom line, there are some bases for refusal that you can overcome. There are others that you can't, and if you can't, then unfortunately you have to start over with a new application and you don't get your filing fee back.
Great. Again, thank you so much, Craig, for your presentation today. And thank you for staying on with us until we finished up. We really, really appreciate it.
And I thank you for the opportunity. I apologize that I was dropped twice, but that's just the nature of trying to do these presentations through Zoom.
Absolutely.
Best of luck to everyone. Stay safe. Thank you.
All right, thanks.
Thank you, Tracy.
All right.